Hello, everybody. Thank you so much for joining us today. My name is Mei Ling, and with me is my colleague Cheryl. Myself and Cheryl, we're both partners in Allen and Gledhill's Disputes Resolution Department, and we have a specialization in white-collar and investigation matters, which is exactly why we're here today to talk to you about recent anti-money laundering developments in Singapore.
Hi everyone, thanks for joining us today. So as Mei Ling mentioned, we're here to talk about a very exciting topic that has been dominating our headlines for the past 2 years, money laundering. So most of you would have been following, or at least I have been following the $3 billion money laundering case very, very closely from the day that someone jumped off a balcony until recently when the MAS took enforcement action against various financial institutions and their employees. So Mei Ling, both of us were involved in various investigations for FIs, for developers, for estate agents, etc. in relation to this money laundering matter. And now that enforcement action has been taken by the various regulators in relation to this case, what are your views on the enforcement action taken? Does it accord with what you had expected?
Yes, sir. So I think as you've alluded to, it's been sort of a really big case. It's been, I think, closely watched by the media, right? Everybody was sort of, closely following all the newspaper reports with photos of pink Bentleys and Rolls Royces, Birkin handbags, right? And as you mentioned, right, there actually was a money launderer who had sort of jumped off the balcony and was hiding in a drain and had been arrested. And so I think from an enforcement perspective, what we saw very quickly was that the individual money launderers were taken to task very, very swiftly. They were charged, right, prosecuted, convicted, and then sentenced to the relevant imprisonment sentences. And of course, as a corollary from that, because we're talking about money laundering can only take place, right, in the setting of a financial sort of system, right, an industry, a property industry, so on and so forth. And so what we've seen culminated, I think, this year is really the various enforcement actions that have been taken by different regulatory agencies. So speaking as a lawyer, right, first up, you have the Ministry of Law, who has taken action against, at present, I think the count is 4 law firms and a lawyer. And that's been in respect of their involvement in conveyancing transactions where it was found that they didn't sort of adhere to the relevant anti-money laundering regulations. Aside from that, also on the property front, we've seen the Council of Estate Agencies take action against 2 errant estate agents. And I think we continue to watch this space because at least for the Ministry of Law, I think there has been some indication, right, that their investigations in respect of certain other law firms are still ongoing. But to the sort of big, press release that came in July this year, and that is the MAS's enforcement action. As Cheryl mentioned, we had been involved in some of these investigations, right? The MAS has not stated how many financial institutions they investigated, but there is an indication that it's been more, right, than the financial institutions they ultimately took enforcement action against. So has there been expectation that there would be some regulatory enforcement? I think the answer is yes, right? What we've seen in terms of the outcome of the enforcement investigations and action now is that the MAS gave somewhat detailed reasons for the issues that they had identified and they had proceeded against. And I thought what was interesting was actually in terms of the 9 financial institutions, right, that the MAS proceeded against. They are very big names, right, well-established, long-time sort of big names and heavyweights, right, in the financial industry. And as a result of that, one thing that the MAS did point out is that for many of the financial institutions, there clearly were established anti-money laundering policies and processes. And so what it was the MAS found, a matter of implementation in some of these cases. One other interesting takeaway is whenever you're dealing with regulatory investigations, as lawyers, we're always asked, okay, is there a risk that individuals, right, might also be penalized other than the corporate entity? And we did see in this case that MAS did take action. They issued certain prohibition orders and reprimands against some individuals amongst the sort of 9 financial institutions. It wasn't every financial institution that had an individual who also received, a penalty, but MAS, in sort of deciding to take action against some of the individuals, I think what the MAS noted was that there were certain scenarios where, for example, a business, when it sort of started out, perhaps was not as big, and then the individuals responsible for ensuring that your AML policies kept up with the growth of business, then didn't, sort of keep a close enough eye on that. So I think that indicates to us that in the anti-money laundering space, the enforcement agencies are certainly taking things seriously, and that breaches of anti-money laundering legislation can result in penalties for the corporate entity, but also in certain circumstances can result in penalties for the individuals.
Thanks, Mei Ling. I think we can all be sure that our authorities have never hesitated to take action against the naughty people involved in money laundering, involved in corruption, etc. And even prior to this $3 billion money laundering case, you would recall, and I think we were likewise involved in that, there was the 1MDB matter as well, which honestly is still seeing certain enforcement actions being taken up to recent times. So if you were to, I suppose, take a step back and look at all these developments in the AML space, first 1MDB and all the way to now with the $3 billion money laundering matter, what do you think would be 3 key takeaways?
3 key takeaways. I think one takeaway is that, when it comes to corruption, for example, Singapore has always said that we have zero tolerance for corruption, right? And that has been the case, as we've seen again, sort of, recently. In the money laundering space, money laundering is slightly different from corruption in that when we talk about money laundering, it's certainly not just a Singapore problem, right? It is actually a global problem. And with all sort of significant big money laundering syndicates, nobody money launders in just one country. What the money launderers do is, they sort of work through different jurisdictions, they move monies in and out. Naturally, any big financial systems are going to be targets for that. So I think one takeaway is that enforcement action, right, is certainly going to continue in Singapore. The second point, I think also, is that as we've sort of seen, the individuals getting involved and the enforcement action that's been taken, together with that, we've also seen the MAS, for example, introduce sort of new legislation. So it's not just about taking enforcement action and dealing with matters, after they've discovered that there are money launderers operating in Singapore. Now, to be clear, the financial institutions are sort of not the naughty people in the sense of the money launderers, of course. But why do regulatory agencies take action against law firms, against financial institutions? It's really because when we're talking about something as international and global as money laundering, if the relevance of parties in the financial system are not sort of adhering with their relevant obligations, then it becomes very, very difficult, I think, purely from an enforcement against the actual bad guys perspective to put a stop, right, to money laundering. So I think the second takeaway is that in terms of regulation, we've also seen sort of increased regulation, and that's, something that has got, I think, a lot of people in the industry talking about. For the third takeaway, I'm not sure I have sort of a clear third takeaway, but I think it will be that lawyers continue to remain sort of important in this type of landscape. I think as we've seen the roll-up of new legislation, there's also going to be a period of time where the relevant players are going to need to figure out, right, how to practically apply sort of increased legislation, increased requirements when it comes to due diligence. And I think that's something that's, that's a space that should be continued to be watched. And that ties in actually, with our ongoing FATF, right, assessment. So Singapore is presently undergoing its FATF assessment. And, when we talk about increased enforcement, when we talked about increased legislation, that is also actually really because, we're wanting to adhere to the relevant international standards, right, that many countries around the world are looking to sort of impose and enforce. But Shara, I was wondering, I mean, I've spoken and touched on a little bit in terms of the recent, amendments to legislation. And I thought, it would be good to get your views on how you see that. Have things become too heavy-handed, right? How do we balance sort of the cost of compliance with, maintaining a good legal system, with limited avenues for money laundering?
Thanks, Mei Ling. So, if we just take a look at how our laws on anti-money laundering have developed in the past 10, 20 years, you will see that our government has really started to look at more and more sectors. We started to regulate more and more sectors. So we started off, of course, with the traditional financial institutions, and then we expanded the scope to cover accountants, lawyers, precious stones and metal dealers. More recently, developers were also subject to AML legislation in 2023. We've also extended our AML legislation to cover payment services providers. And today, where we are at, there has been a very, very recent change in the AML legislation covering all of these regulated sectors. And as Mei Ling foreshadowed earlier, this ties in with the FATF mutual evaluation, which took place sometime in July 2025 this year. So if you just generally look across the board, you will realize that whilst there are small nuances and differences in the AML legislation covering all regulated sectors, they are typically the same. They typically cover general customer due diligence, enhanced due diligence, ongoing monitoring, filing of suspicious transaction reports, record keeping. So that's in line with the FATF requirements. But maybe let's talk a bit more about what the recent changes in the legislation have been. So across the board again, the MAS has issued new notices for financial institutions, for REITs, capital market service providers. So they have done that. And you will see that the other ministry, the other regulators have also done the same thing. So the URA, for example, and the COH, they have issued notices for developers. For Ministry of Law, that's not out yet, but I think we are going to be expecting new guidelines for lawyers as well. And if I could touch on a few of these new changes. The first, I suppose, overarching change will be that we are now extending our legislation to not only cover anti-money laundering and countering of financing of terrorism, we are also going to cover proliferation of financing. So that's across the board. You will see the changes in the laws applicable to all regulated sectors. What exactly is proliferation financing? Honestly, for me, I see it as somewhat related to financing of terrorism, but it's a bit more focused in that it focuses on the funding and financing of the production and the use and the circulation of weapons of mass destruction. So the focus for proliferation financing, at least, is on two countries. Firstly, Iran, and secondly, North Korea. So that's one big area of change that we see. Two more areas which I think are the most practical, based on, of course, my own views, but you can take a look at the notices and come to your own views, would be number one, the timelines for the filing of suspicious transaction reports. So under our previous regime and under our CDSA, which is the legislation that requires us to file suspicious transaction reports when we suspect that certain funds we're receiving or property that we're dealing with could constitute proceeds of crime. We were required to file a suspicious transaction report with our authorities as soon as reasonably practicable. And we face a lot of questions from our clients, right? What does as soon as reasonably practicable mean? Because sometimes I take time to investigate the matter. Sometimes I need to ask queries of my clients. I need to understand where these funds come from before I can assess whether something constitutes a suspicious transaction. So again, across the board, all the guidelines now state that I must file a suspicious transaction report within 5 business days of coming to an assessment that the transaction is suspicious. So if I could just break it down in terms of time frame, right? let's say I'm the compliance officer and my colleague, someone who does sales in a bank or a relationship manager in a bank, tells me, hey, there's this transaction, it's potentially suspicious. I can take some time to review the documents, speak to the RM, understand the transaction a bit more. There is no specific time frame within which I must complete these investigations, although, of course, we are supposed to do it as soon as possible. Thereafter, once I have decided that this is a suspicious transaction, then I have 5 business days to file my suspicious transaction report. To make this a bit more complicated, there is a certain exception to this rule, which is that if the suspicion relates to dealing with sanctioned entities, then you are required to file the STR immediately, if not within 1 business day of such a suspicion arising. So that's where we are at right now in terms of the timelines for STRs. Honestly, I think it's quite a welcome change because previously there was a bit of uncertainty in terms of what the time frame ought to be. And I think that, having this time frame, whilst 5 business days might not sound too long, it does show the importance that our regulators are placing on filing these STRs with our authorities. For the $3 billion money laundering case, for example, actually, a lot of STRs had been filed by the FIs, and this was one of the mechanisms through which our authorities actually gathered intelligence and eventually could arrest these 10 people and seize their assets. So that was because of a lot of work had already been done behind the scenes by the financial institutions, by other regulated sectors that allowed our authorities to gather the necessary intelligence. So that's another big change that I see in our legislation in the guidelines. And the last one, I think, would be increased guidance in how we determine and assess source of wealth and source of funds. So most regulated sectors will be required to go through source of funds and source of wealth for their clients if they have to apply enhanced customer due diligence. And Mei Ling, I think you will recall in some of our investigations where we were handling the $3 billion money laundering case, there were actually a lot of issues in terms of the steps taken to determine source of wealth and source of funds. For example, can I just accept a statutory declaration from a client stating that these funds are from my father, they were a gift? And the guidelines now make it very clear that you cannot do that when you're applying enhanced customer due diligence. And necessarily so, right? Because a lot of times these clients might not be in Singapore, and the effect of a statutory declaration is quite limited when the person giving the statutory declaration is not located within jurisdiction. And therefore, we are required to corroborate source of wealth and source of funds with independent source of information. And honestly, there's quite a lot of information we can look at now, especially with the internet. You can go online to companies' registries, you can do just a general Google search would turn up relevant information. It really, I think, doesn't change what we have always been supposed to do, but the guidelines now really set out in a lot more detail the steps that we are required to take, which again, I think is a welcome change because it really shows the emphasis that our authorities are placing on all of these steps that need to be taken by regulated sectors, which are the gatekeepers to prevent all these money launderers from coming in. Yeah. So that's what I see as the main changes in our legislation.
I think picking up on that, and STRs and SOW, right? So suspicious transaction reports and source of wealth, they're always sort of the 2 big questions you get when you're talking about due diligence from an AML perspective. On STRs, I sort of echo Cheryl's views in terms of, yes, instinctively you might sort of see the change from 15 days to 5 days as, now it's the same thing, I just need to do it in a shorter time frame. I don't think that's necessarily the case because I do think that it's now sort of clearer that the timeline starts running at the point of time that you have those sort of reasonable grounds for suspicion. And so that ensures that an investigation, you shouldn't take your own sweet time with it, but an internal investigation that is necessary can be done. One thing that I thought was interesting from an STR perspective, so as Cheryl alluded to, we quite often have clients come to us and they'll present a certain factual matrix and they'll say, do you think that this arises or gives rise to significant causes of concern? Am I just being sort of very careful, or do you think I actually really have to file an STR, right? Is this fishy enough? Is this dodgy enough? And sometimes what clients do is they take the approach, okay, let's just err on the side of caution. It would be better for me to file an STR than not to, because if I file, if it turns out it wasn't a dodgy client, so be it. But if I don't file and it turns out it was a dodgy client, then I might get into trouble. And if you look at the MAS enforcement action that was taken in July, one of the issues that the MAS had raised was that there were financial institutions who had filed STRs, but where there were issues then was that post-STR filing, right, they either didn't, re-rate, right, the risk rating of the client as they ought to have done, or they didn't continue monitoring the transactions. So I think one important thing, to bear in mind is that you do have to assess whether or not there is an obligation to file an STR. But even if you do, right, so even if your assessment is yes, you do a good job, you filed a good STR, that doesn't mean that that's where the risk of liability ends, right? If you're going to be continuing the relationship, whether it's because, you don't want to tip off the customer, or whether it's because your assessment is that there are slight amber flags, right? But it's not clear enough for me to sort of make that decision to come out of the relationship. Nonetheless, if you've done that, you probably really do need to think about how you're going to manage that continuing relationship moving forward. I think when it comes to source of wealth, as Cheryl said, the amendments don't really sort of change the real essence of what needs to be done when it comes to source of wealth, right? When we talk about source of wealth, what it really means is that if you have a customer that you're onboarding, you really need to figure out whether or not the wealth of that client is legitimate. And one thing we've seen in the investigations that we've done is that sometimes you can have very sophisticated money launderers, right, who can forge documents. It's impossible to tell, right? I mean, if you're not a forgery forensics expert. But at the same time, actually, I think we've also seen in the investigations that somewhat surprisingly, sometimes these money launderers really do slip up and they do make mistakes when it comes to, giving documentation in terms of source of wealth. So one thing I would say is that I think when we talk about any regulated entity, right, that has to do source of wealth due diligence, you really do need to train the people on the ground. It's not a box-ticking exercise. It's not just a matter of I need to obtain a supporting document, right? But the relevant sort of relationship manager, or if it's the compliance team that's doing a second check, they really do have to try and dig in deep in terms of understanding, what is this transaction that allegedly gave rise to the increase in wealth? What are the types of documents I would expect to see, right? Do the documents make sense? Where, for example, you're asking your client for financial statements for 7 years, and then they give you a pile of financial statements, all by the same auditor, and then all dated the same date, right? Even though it's for 7 different years. Those are the types of red flags that I think we really need to train our frontline guys, right, to be on the lookout for. And I think that's going to be an ongoing process. It's going to be ongoing training. But yeah, I really do agree that, the amendments, would we have expected amendments post a $3 billion money laundering case? The answer is probably yes. But I think at the heart of it, right, just as the amendments sort of are in line with, what the international community is pushing for, I think similarly that the heart of what we need to be doing really does remain the same in that sense.
I would categorize the amendments as actually a lot of them were learning points from the $3 billion money laundering case. So, just another example, if you look through the red flags now, a lot of the guidelines have updated red flags, and you will see that one red flag, for example, is whether or not the client has come from any residency by investment or citizenship by investment countries. So that really arises from the money laundering case that we all just dealt with, because a lot of these people might have been born in a certain country, but by the time they came to Singapore, they were holding passports from various other countries, which I shall not name in this video. But if you Google, you will know that there are just certain countries that one needs to be more alert about. And really, at the end of the day, I think our legislation is always just developing and adapting and addressing the cases that we've had to deal with. And it's constantly developing. And I do think that from this $3 billion case, there are a lot of learning points. So Mei Ling, I suppose if I were to just ask you where you see enforcement action moving towards in the future, do you think that this $3 billion case was a one-off matter that, we really just had to make an example out of these people? Or do you think that we will continue to clamp down on all the regulated sectors and make sure that we are properly protected from all of these naughty things that might be going on in our shores?
Yeah. I mean, I think if you look at Singapore's National Risk Assessment for money laundering, it's quite clear that there's been a lot of work put into to identify the relevant sectors and industries where there may be a little bit more risk. So I'm pretty sure that this is not sort of the last money laundering enforcement action we're going to see. In fact, post the 3 billion money laundering case, there've been other sort of investigations, obviously not of $3 billion, right? But other money laundering investigations that have been ongoing, other money laundering enforcement actions that have been taken. So this is definitely not going to be the last of that. If you look at the National Risk Assessment Report, I think the primary industry that was identified as having the highest risk was that of banks. That's to be expected because banks is where money sort of flows in and flows out. At the same time, banks are also the sort of highest regulated industry, right? And banks ordinarily have really big, well sort of experienced compliance departments, right? And so with most banks, you would already have policies and processes in place. And I think there it's a matter of continued sort of training and implementation. One area, which I think has also been under scrutiny is corporate service providers. So as I mentioned earlier, when we talk about money laundering, it's not always foreign actors, but quite often it is. And in a lot of cases, what the foreign actors would do is go to different countries, right? Set up shell companies. In Singapore, if you're setting up a Singapore incorporated company, you would all know you need a locally resident, right, director. And so there are, nominee directors who sometimes will hold 500, 700, 800 directorships, right? And I think we've already seen, from ACRA's perspective, quite a bit of enforcement action being taken there, where if those nominee directors are errant, not necessarily in terms of money laundering matters, but if they're sort of not carrying out their duties, ACRA doesn't hesitate, right, to take action. And now that for corporate service providers, there is now specific anti-money laundering legislation and requirements that they have to undertake. I think that's one area as well where, if we sort of crystal ball gaze, I think we would expect to see possibly enforcement action taken in the right type of cases.
And I think this enforcement action actually always goes hand in hand with legislative changes. So taking the example of corporate service providers, quite apart from the enforcement action that has been taken, you also see increased regulation. So for example, now the nominee directors are only allowed to provide services through a corporate service provider. So there's more regulation there. They're required to be fit and proper person. So it's moving towards the requirements applicable for financial institutions. On top of that, we've also had requirements now for all companies incorporated in Singapore to have register of nominee directors, registers of nominee shareholders. So I think legislative change would come hand in hand with enforcement action moving forward. And at the end of the day, FedF is going to come to our shores again in a few years' time to do that assessment. So we shouldn't just rest on our laurels and think that this round of legislative changes and this enforcement action will be the end of it.
Yeah. I mean, I think as a last takeaway, and hopefully a positive one, I think when you see a sort of growth of money laundering enforcement, it's also because Singapore, really is such a large financial industry and financial hub, right? And therefore, when we have so much money flowing through our shores, so much legitimate money flowing through our shores, naturally, right, as a corollary of that, there's necessarily going to be some dirty money. So I think we can take comfort from the fact that, Singapore will continue obviously keeping our doors open for business, but at the same time ensuring that from a legislative and enforcement perspective, we remain sort of a clean, right, society, and we don't hesitate to take action where necessary. Thank you so much for joining us today, and that's where we'll end off today, and it was a real pleasure to spend time with you. Thank you.
you.